First, a disclaimer. Nothing I am saying is on behalf of the Director of National Intelligence, nor the Defense Department Inspector General. I am under a non-disclosure agreement, so if there are questions that might touch on classified information, timely with this topic, I will talk around the classified information rather than reveal it on a uncleared line. Okay, so let's chat a little bit about the overview here we have for Guideline K. Guideline K is kind of the heart of the adjudicative guidelines. So remember that the adjudicative guidelines are issued by the Director of National Intelligence for the entire executive branch. There are different series of regulations for the judicial branch and for the legislative branch of government. The executive branch regulations cover roughly about 72 different security offices. Everybody who's basically a military member, a cadre, which would be a federal employee, or a contractor who works for a company that is doing business with a federal agency in the executive branch. Within that, there are two guidelines which are really key to the personnel security system. Okay, there's 13 overall, A through M, but it's K and M that security really places close attention to. The others are important, but they really are background to K and M. K is handling protected information. It's named that way for a very specific reason. It's not handling classified information. Your behavior with respect to protected information is also of concern to security. And Guideline M, misuse of information systems, is sort of adjunct to K because with the rise of the internet, with the rise of cloud systems, network systems, we know that classified information can be especially vulnerable electronically. And so that was added as technology started to increase the ways we could access information. So what are the types of protected information that you might not be thinking of? If you attended university, any types of violations of a university's internet or mainframe or computer systems, any inadvertent disclosure of their protected information or privacy protected information, if there's a judicial administration about that, if you have any kind of record with that university, that could end up hurting you and hurting you significantly. I've seen plagiarism play into this one. So if you are wrongfully publishing as yours somebody else's information, that could be a Guideline E. I've also seen it as a Guideline K. If you have any banking issues, aside from criminal issues with fraud, but if you've done anything over an electronic network that violates the handling of confidential or proprietary information of a corporation, that could come back to haunt you under a Guideline K. So don't think of it as just, I don't have access to classified information, so I don't have any Guideline K issues. And then we'll talk a little bit about best practices to adopt when working on classified information. So this slide I use regularly in my webinars to kind of remind people where this fits within the general world of national security law. This is the table of contents from a popular treatise that's used to teach attorneys primarily how to do national security law issues and matters, how to handle them. And as you can see under number 39, it's a tiny area. So for all of the things that come up, if you're sitting, for instance, on the National Security Council, this whole area that we do webinars on with security clearances fits just within that tiny number 39 there. Remember also that in the context of a security clearance or adherence to the adjudicative guidelines, there's a pyramid of access in the federal workplace. So everybody requires credentialing if you're going to be in a federal facility. So you don't have to be deemed suitable for employment, or you don't have to have a clearance. But if you're on site for some particular reason that's uncleared and not in a contractor status, maybe you're just visiting, you're going to have a credential. And there are standards for credentialing. And sometimes people are denied credentialing, and sometimes it's appealed, and sometimes it's successful. Suitability is the next stage up on the access pyramid. So everybody must be suitable if you're a contractor or a federal employee. The key thing to remember is if you go for a clearance, you will have a suitability review. You don't always know what's going on because it's embedded in the security clearance review. But you may be in a position of not requiring access to classified information. And so you end up having a suitability review, which is one step below. You may know of suitability by its other name, public trust. So if you fill out an 85, SF 85, typically that's a public trust position. And then if you're filling out an SF 86, that's a clearance position. Now there's a little band in between the two, an 85 that's treated like a 86. So in some agencies, they will do a sort of an amplified suitability review. And then the other tricky thing to remember is sometimes your position will not require a clearance, but they'll make you go through the investigation anyway. And so they have you as investigated, but they don't actually grant the clearance. That's sometimes done in case you're sort of in the reserve bullpen for some particular project and they need to elevate you in a hurry. They want to have the work done. And then at the top of the pyramid are the special access programs, which are not a system of classification. It's a special access program, which is independent on its own. That has a particular program manager who is actively out there every day deciding whether people actually should have access to particular silos of information. And SAPs generally, if you are being challenged on a SAP, it's very hard to win a challenge on a SAP. It can be done, but there's great discretion given to the SAPCOs, that's what they're called, when you're dealing with a SAP. So we're going to talk here about Guideline K, which is the handling of classified information. This means information that may be in a secured compartmented information facility, a SCIF, or it may be something that is in a safe, something online, and there are certain rules you need to follow. And we're going to talk here a little bit about some of the best practices to have when you're in that situation. Where does Guideline K fit within the general adjudicative guidelines? So after this call, I would like our participants to go and read SEAD 4, SEAD 4. It's an acronym, the number 4. If you type that in with the word security into Google, it comes right up. You're looking for the 2017 version. And then in this is my wheel of adjudicative guidelines here. Starts out with the allegiance to the United States, one that was not often adjudicated, J6. There were a ton of adjudications on this, not too many statement of reasons issued. Then you get into Guideline B and C, which are about foreign contacts. That's a little category of its own that those two deal with. Then you get into the personal behavior guidelines. And then after those, those are basically guidelines D through I. And then you get into criminal conduct, which is kind of a joker in the deck. It's tagged on with other guidelines when you're reviewed as a security concern. Guideline J looks a lot like Guideline E because basically when they made J, they cut and paste the text into from E and just change personal to criminal for most purposes. Then you get into Guideline K, which is ours right there in on the lower point, probably at about number 7 on the clock. And this is where you get into K, L, and M, the very end of the guidelines. These are the ones that deal directly with the handling of information or contacts that could be problematic for a programmatic sense in the security field. SEAD 4 is the samurai code of the federal workforce. It's the set of rules you agreed to abide by when you took a clearance or when you applied for a clearance. And I find that too many people don't read this directive on an annual basis. You should read it week of your birthday. Don't do it on your birthday. It's kind of geeky. But the week of your birthday, you definitely should read this every year just to refamiliarize yourself. All right. So we've talked about the security executive agent directive number 4. There's a number of SEADs. The two most important for your purposes on your personnel security clearance are 4, and the one right before it, 3, which is the self-report. Um, for the general issues on handling protected information, the regulations divide into 2 parts. What presents the concern, your daily behavior with respect to classified information, and then the second half of the regulation are what mitigation factors could be there to help you keep your clearance in the event you're found to have mishandled classified information. We'll talk about past cases in conjunction with the next slide. Current liabilities and assets. So let's talk about current trends in the case law and who might be most liable. This is what I see in my cases as I handle these going up in front of the Energy Department, the Defense Department, all of the intelligence community elements. So there's a common thread of cases of people who fall into the trap of we've always done it that way. Somebody in the office becomes the kind of local security expert and isn't particularly focused on the details of the regulations. And you start doing things in a way that everybody agrees to in the workplace, and then you get trapped. Okay, you've done something wrong, you violate the regulations. Going to security and saying we've always done it this way is really a poor strategy at that point. Why? Security was probably in on the poor practice to start with, right? Security managers may not always be doing their job well, and throwing your security manager under the bus usually isn't a successful strategy to keeping your clearance. So you need to stay up on security practices. You need to stay up to date. That means you need to read yourself. You need to go and look at PowerPoint presentations, look at what are the particular practices that are required, look for citations to regulations when you see documents that describe security practices. You can always ask your security manager. That's a good thing to do, but you need to be studied up independent of your security manager, because your security manager, first and foremost, is there to ensure the regulations are enforced, not necessarily to coach you. And they're in a conflicted role. They're the enforcer, and they're supposed to be advising you on security practices. But how can you be an enforcer over a system where you advise the individual on how they're doing what you're now enforcing? Okay, it's a very difficult job for a security manager. The next one, those who obsess on the handling of classified information. I see a small line of cases where employees are repeatedly asking questions about security practices for the handling of protected information. You want to encourage that in the workplace, but at some point, security is going to wonder why you are repeatedly asking questions that other people aren't asking. Maybe the training's not being done correctly. They can make some adjustments for that. Or it may be that you're involved in something that is leading you to be obsessive about security handling practices, and that something may be a leak, or that something may be a theft of classified information. I've seen this go so far as to have employees subjected to psychological evaluations, okay, for paranoia. So you need to be careful. This is why studying up yourself is a better strategy than repeatedly going to your security manager. And then your annual training, it's insufficient. Sorry, it's insufficient. I used to supervise annual training in the security field, and it's insufficient. I don't know how we're going to make it better, but for some reason we've decided to dumb down the training, and there really isn't enough detail there for you to be in good shape. And let's also be very frank about it. A lot of people just skim through those slides and don't actually read them. Another one, favorite of mine from my service as an intelligence officer, I had a SES who is a long-time member of the intelligence community explain this to me. Security snobs. There are people who think that they hold a particular rank in society because of their level of access. This is a problem for security, because a person who's a security snob is going to start letting their security access affect the way they view the handling of classified information in the workplace. In one respect, it can make them very careful because they want to protect what they perceive as their status of having a security clearance. On the other end, though, it's focusing on you as the individual and not on the information that belongs to the federal government. So a security snob is acting inappropriately within the system of personnel security because they've made themselves the focus of the regulations and not the protection of the information. So you want to be very careful about that. Excuse my French, but snotty comments to your coworkers about how you have more of a clearance than somebody else is not a good idea. If you're in the classified workplace and you have access to one of the many databases that gives people's security level, don't go Googling on your coworkers unless you have a need to know on that stuff. Why? Because security's watching you as you go and do that, and they're going to wonder, why is this person checking on to our database of who's cleared at what level 4 or 5 times a day? And they're going to start wondering about your physical, mental, behavioral health. Relying on the treatment of others. Frankly, they don't care if the person 2 cubicles down took an, information home that was classified, brought it home the next day, didn't handle it properly. They don't care about it to the extent that it seems okay for you to do that. Okay, they're not under any requirement to treat similarly situated people the same. You may be believing that because you've been trained in the EEO context that federal workers should all be treated the same manner, independent of any particular category that they fit into. But for security, they can treat you differently. Somebody could have completely violated the regulations for some reason, and security may have a good reason not to punish them. And you do the same thing, and they can hammer you. Okay, this is an Article 2 process. Okay, it's under the president's powers directly. All those protections that you associate from watching Dragnet or Hawaii Five-0 or Kojak or any other number of 1970s and 60s police shows, those equal protections don't apply under Article 2. Article 2 is the president's private reserve. Your security clearance is a privilege. It is not a right. Okay. And then taking shortcuts and not remembering that something needs to be marked. So it does not need to be marked. So remember that with classified information, they can classify it after you've handled it and punish you for mishandling classified information. Happens quite often. So you need to approach not only looking at the markings, but also looking at the material and thinking. Be a thinking handler of classified information and ask yourself, is this likely to be classified? Maybe it hasn't been marked yet, and should I handle it appropriately? Never rely on the fact that something's posted on the internet and unmarked to tell you that it's unclassified. That gets people into trouble all the time. Okay, and if there's classified information on the internet in the open, if security notifies you not to look at it, do not go look at it. Okay, that's an offense in and of itself. So you need to be a savvy user at that point. Remember that your security process is part of a feedback loop, okay? So we have external threats to the federal workplace and we have internal threats. So the Chinese and the Russians are actively trying to steal our cheese, okay? And you need to be sensitive that if you're sloppy in the handling of classified information, you're making it easier for them to steal our cheese. That's being an unwitting fool. The other side is the internal threats, people who have problems in the workplace, not whistleblowers. They're legitimate as long as they go through the right process, but they could have other problems. They could be envious of their boss. They could be disgruntled for any number of reasons. They could have family problems at home. They may have a child that's just turned out to be evil and bad. They may have a problem with their spouse. For a variety of reasons, they get unsettled in the workplace and they become internal threats. So the process of correcting our system and keeping it sealed and the information inside our circle of trust requires not only vigilance on external threats, and we rely on security to do that primarily, but you're important for that too, but also vigilance on internal threats, okay? And the internal threats is understanding your workplace, understanding the proper handling procedures, and understanding when somebody else may be a threat. And that requires you to report under SEAD 3 that there's somebody who might be a threat in the workplace. If they're offending a profile of a good security citizen, you need to report them. Yes, is it a snitch culture? You bet it's a snitch culture, and it's a lawful snitch culture, and it's one you need to adhere to if you're going to be seen as a reliable and safe security citizen. All right. Any questions? How are we doing on questions?
We did get one question. It says, is declassified information also protected information?
So declassified information can be protected information. It could have Privacy Act protected information in there, and that's protected information. So just because somebody else mishandled it and posted it doesn't mean that you need to repost it or send it in a way that's inappropriate for PPI or any other number of protected information categories. So if you are currently not in a cleared job, say you're at a university getting ready to apply for a clearance, and you download on the university system songs or videos stealing the proprietary property of a corporation without paying for it, you've just triggered Guideline K and Guideline M. So as I said at the beginning, don't look at this as declass versus unclass versus classified. If it's a proprietary information, if it's protected, then you need to abide by the rules in that system of protection.
There is another question that came through that says, what is the latest form for a new applicant? Is it EQIP or the SF-86?
So actually, EQIP is now outdated. There's a form after that one. So the best way to approach forms is all of the online PDFs for SF-86 and 85s, as long as you get the most recent date, are helpful guides. But remember that agencies can have tailored forms, so they may vary between whether a question asks for back to 7 years, back to 3 years, back to 5 years, or forever. You could be applying for positions at 2 different agencies, and there'll be subtle variations in those questions. So the EQIP was simply the electronic version of the SF-86, and you could use them interchangeably if you were a security officer. There's now a new form, okay, which DCSA has been rolling out over the last 60 days or so, which is the replacement to the EQIP. I'm hearing mixed reviews about it. I'm still sort of trying to get my professional opinion around it. But your security office will supply you with the version they want to use, or the HR office if you're being recruited. But you can always go and look at an SF-86 online in the PDF version and get a good idea of what information is being required. And then remember, all the questions on an EQIP map to one or more of those adjudicative guidelines in SEAD 4, which I just shared with you. That's why you should read SEAD 4 regularly, and you should read it definitely before you fill out an SF-86, because there's a method to this madness. We had a bunch of scandals in the 1980s, federal employees and contractors dropping the dime on the federal government, stealing its information and giving it to the KGB, the WASP down in Cuba, the Chinese intelligence services, any one of the 42 Indian intelligence services. They have an incredible number over there. You know, the bottom line is 1980s, 1985, year of the spy, you know, the Russians ate our cheese. Okay, they're the enemy. They ate our cheese. So we took all of those lessons learned and we developed the adjudicative guidelines, the 13 guidelines you've agreed to live by. And then we developed the forms from those. And so there's a progression from the lessons learned from the year of the spy to the SF-86 to the EQIP, and then the new form that was developed from it. Those all are united by SEAD 4, which is the distilled guidance of what you should be relying on.
We did have a follow-up question based on the unclassified information. If it is unclassified, is it also protected?
Well, it can be. Okay, if it's unclassified, it's not protected as classified information. So a federal official who's got originating authority has gone through, reviewed it, decided it's no longer classified, and they'll line it out. The secret line will be lined out. But if that document has PPI on it, somebody's social security number, it probably should not have been posted without that social security number being redacted. So the social security number has nothing to do with classification under the security system, but it has something to do with PPI, and that's protected information. So you have to look at the information that's there, and I would not rely simply on a declassification to tell you whether there isn't some piece of protected information on that document. You want to go in and check it. So that's the key point there. Now, what's the rule generally in the federal FOIA world for release of information? If you're a GS-15 with program responsibilities or above, your name's going to be in the clear. Okay. Yeah, you're part of the inner circle. You can take responsibility for what you've done in life, and your name's going to be out there. So a Secretary of Defense or the DNI, their name's going to not be redacted on a document that's been approved for release. But if you're a GS-15 without program authorities or less, if you're GS-14 or GS-13, your name's going to be redacted before they release it, or should be. And definitely, if anybody's social security number's on there, it should be redacted. If it's not, then there's protected information on there, even though it's a declassified document. Does that make sense?
They asked a follow-up question of if this applies as well to unclassified handwritten documents and or notes.
So if there is information that is classified, written down, but unmarked, then if that's outside of a protected environment, then you are responsible for the proper handling of that information. This becomes a problem because you may not know. You have some notes you found on the internet, somebody scanned and put up, and you don't know whether it's classified or unclassified. You look at it, and it looks a little scary. So what do? Well, you talk to your security officer, because it doesn't have to be marked, and it doesn't have to be typed. It doesn't have to be any sort of official format. It could just simply be notes. This becomes a problem with the note takers in the federal government. There's kind of two categories of people: those who bring nothing in and out of a secured workplace, and those who do. Okay, those who bring nothing in or out have usually learned a professional lesson watching other people fall on their sword, that taking things in and out of a secured workplace can be very dangerous, right? You could have inadvertently put notes or something in there. The people who keep records are often tempted to take them with them when they leave, okay? Senior officials get into a lot of trouble. There's a whole group that keep those green log books of everything they do. They record every day what they do, and then they take them into retirement. They're sitting in their home, and some of that information is probably classified. So you have to independently look at the information, get a sense of whether you think it's classified, and if you don't, then you need to ask your security officer. Okay, thank you. Have a good day, everybody.